a bar fight, one split-second decision. And now a father of twins is staring down a possible 20-year prison sentence. But when Judge Stephanie Boyd uncovers what really happened that night, the courtroom takes a shocking turn. Will he walk away with a second chance or lose everything?
Oscar Salinas.
Defense.
Clarissa Fernandez Pratt for Snow.
And are you Mr. Snow?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Snow, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, next I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonition. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault, serious bodily injury? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Snow, I'm going to has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, did you review that with your attorney? Did you understand it?
I did, Your Honor.
According to the plea bargain agreement, there's a $1,000 fine. State recommends deferred adjudication. They will take in consideration County Court Cause number 688355. There's to be restitution to Timothy Knox, K-N-O-X, and Storm Buscher, B-U-E-S-C-H-E-R. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
To be filed, we haven't heard. Thank you.
Then I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 years, that there be a TAP evaluation, and no contact with Timothy Knox and Storm Buscher. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Until the offense is charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the plea?
Yes, Judge. State offers what's in Marcus State's Exhibit 1 and its attachments and evidence.
No objections from the defense?
Mr. Snow, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing?
I believe so, Your Honor.
All right, anything you wish to say on behalf of your client?
No, Your Honor, this was a one-time incident. With respect to the incident that night, he is very remorseful for what happened. He certainly didn't intend to cause serious bodily injury, but that was the result of what his actions, how he hit the gentleman's face.
So I'm trying to figure out why this happened. So you're at a bar and I'm reading that there was a female who was dancing and the police report says erotically on the dance floor. And then you charged the group. Was this female who was dancing? Was that your girlfriend? What was she to you?
Your Honor, it was my wife. And she wasn't erotic.
Well, that's what they said.
Yes, Your Honor. Okay. Well, yes, Your Honor. But they were harassing her, like bullying. It wasn't like anything like that. Nah, I made the stupid move to defend my wife with violence, and then a fifth guy jumped in to break up the fight. In that moment, I thought he was participating in the fight, and I hurt him. And I look forward to the opportunity to make that right through restitution. And
all right. So were you drinking?
No, Your Honor. My tab that night, I think, was $8.
Do you have any children?
Yes, Your Honor.
What are their ages?
I have 11-year-old twins.
Well, you should know the answer to this question. What's their date of birth?
February 29th, 2012.
Oh, okay.
Mhm.
Usually you'd be surprised. A lot of people don't know the birth dates. So are you employed?
Yes, Your Honor.
What do you do?
I'm a site superintendent for a general contractor construction firm.
All right. Any drug issues?
Not at all, Your Honor.
All right. Any other questions?
No.
All right. This is what the court is going to do. Oh, I'm sorry. One more thing. This Timothy Knox and Storm Boucher, that's the no contact is outside the agreement. I'm assuming you have no problem not having any contact with them.
I have no idea who they are.
Okay. So we're going to do $1,000 fine. That will be probated. 4 years deferred adjudication. Take in consideration County Court Cause number 688355. Restitution and no contact with Timothy Knox and Storm Boucher. Brenda, I will mispronounce that name several different ways. Are you and your wife still together
No, we're currently getting divorced.
because of this?
No,
Okay.
mental health issues.
All right. So I'm going to do 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that. If you do that, 40 of those hours will be waived. We're going to do parenting classes. And once you complete the parenting classes, the remaining of the community service hours will be waived.
Okay.
And to me, you can never have too much parenting classes. They don't give you any of that when you leave with your baby at the hospital. As people know, they're just like, here you go. Good luck to you. So we're going to do that. We're going to do random UAs. Probation. If there's an issue with his UAs at any time, then do a TAP evaluation. And we'll follow the recommendations for TAP. But if TAP wants inpatient treatment, we'll do intensive outpatient treatment to begin with. We're going to do field visits 1 time per month. And you do the field visits for 3 months. If there are no issues with field visits, then you can cease them if probation wants to cease with the field visits. And if probation wants, the field visits can count as reporting. But I am going to order regular reporting by Zoom or in person. And we'll do an anger management course. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else that's needed?
No, Your Honor.
Mr. Snow, is there anything else you need from the court to be successful?
No, Your Honor.
All right. I appreciate you. You always come dressed appropriately for court and you're always on time. I appreciate that.
Well.
I'm sure your attorney has something to do with that. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. Court is calling 2022 CR 10022, State of Texas versus Victor Flores. Can I have parties announced for the record for the state?
Oscar Smith, of State of Texas.
Defense?
Thomas Beck for defense.
And are you Mr. Flores?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Flores, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
All right. State is are you proceeding on the indictment as presented? And standing in now for the state is Marcus Sander.
Yes, Judge, we are not. We're waiving the repeat enhancement paragraph, both of them.
Any objection?
No objection.
The courtroom falls silent as Matthew Snow stands before Judge Stephanie Boyd, facing a charge that could change his life forever. He's accused of aggravated assault causing serious bodily injury, a second-degree felony carrying a punishment of up to 20 years in prison, and a $10,000 fine. From the very beginning, Judge Boyd makes sure Snow understands exactly what's at stake. Every right, every consequence, every possibility is laid out in detail. One mistake during probation, and he could find himself serving the full sentence behind bars. Snow enters a no-contest plea and applies for deferred adjudication, hoping to avoid prison. But Judge Boyd wants answers before deciding his future. As she reviews the case, a troubling picture begins to emerge. According to police reports, the incident started inside a bar. A group of men allegedly began harassing a woman on the dance floor. That woman, Snow explains, was his wife. Judge Boyd presses further. Why did the situation escalate into violence? Snow admits he made a terrible decision. He says he reacted emotionally while trying to defend his wife. During the chaos, another man stepped in to break up the fight. Believing the man was part of the attack, Snow struck him. The result was serious bodily injury. Judge Boyd listens carefully, but refuses to excuse the behavior. Defending a loved one does not erase the consequences of violent actions. Then the focus shifts to Snow's personal life. He's employed as a construction site superintendent. He has 11-year-old twins. He has no history of drug problems. And despite everything happening around him, he appears respectful and prepared in court. But there's another revelation. His marriage is falling apart. When Judge Boyd asks whether he and his wife are still together, Snow reveals they are currently going through a divorce because of the incident. The courtroom grows quiet. This wasn't just a criminal case. One night of violence had already cost him part of his family. After weighing all the facts, Judge Boyd delivers her decision. Instead of prison, Snow receives 4 years of deferred adjudication probation. But this is far from a free pass. He must pay restitution, complete 100 hours of community service, attend parenting classes, take an anger management course, submit to random drug testing, participate in field visits, maintain employment, and regularly report to probation officers. Every condition is designed to ensure accountability. Then Judge Boyd leaves him with a message that resonates throughout the courtroom. This is a second chance, not an escape from responsibility. One violation could bring the entire case back before the court and expose him to the full 20-year sentence. For Matthew Snow, freedom comes with a price. And now, every decision he makes will determine whether the second chance becomes a new beginning or a path straight back to prison.
Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we would ask for credit for time served.
All right, the court will find you guilty. The court will sentence you to 10 months in the state jail facility, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Sir, you're gonna have to stop stealing. And whatever your reason is for stealing, if it's you have a drug addiction, then you need to take care of that. If it's you don't have a job, then you need to get a job. But stealing is not an occupation, and it should not be used as one. You understand? All right, good luck to you.
Thank you.